viewers, Namaskar. I am Dr. Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. We are doing a series on the 3 new criminal laws. This is our 4th lesson in that series. In the previous 3 lessons, we tried to decode the title, understand the reorganization and restructuring and chapterization of those laws. In the previous lesson, that is session 3, we talked about the conceptual changes. In this session, we will continue further with those conceptual changes and we will try to further understand what more has changed in those 3 new laws. So, talking about the definitions, how those definitions they have changed and how the interpretation of the existing terms has changed. So, in section 2, clause 20, it defines month and year. So, what it says? Wherever the word month or the word year is used, it is to be understood that month or the year is to be reckoned according to the Gregorian calendar. See, previously it said British calendar, but this was an attempt at decolonizing our old laws. So, that is why what did we do? When we were decolonizing our criminal justice system in the old law, the old terms such as British calendar, we had to remove those references. So, now we have replaced the term British calendar with Gregorian calendar. Next is movable property. Now, this is going to be a game changer. Why and how? Because see, when IPC was enacted at that time, when we talked about movable property, we were talking about only corporeal property, because at that time we did not have data which was available in incorporeal form. Moreover, even if sometimes we had to face the problem of theft of electricity, we had a separate law to deal with that. So, IPC had defined movable property to include property which was corporeal property, movable property. But now, the definition it has been expanded to meet the changing needs of time. Nowadays, instances of data theft are so common. So, if we would stick to the old definition which defined movable property in a very narrow manner and it was only corporeal or tangible property which could be movable property, then how would we be dealing with so many other kinds of crimes which deal with incorporeal property? So, now what has been done in the Bharatiya Nyaya Sanhita? Movable property, it has been defined in a broad fashion. What does it say? Section 2, clause 21, it defines movable property. It says, movable property includes property of every description except land and things attached to the earth or permanently fastened to anything which is attached to the earth. Now, see, if anything is attached to the earth, if anything is permanently fastened to anything which is attached to the earth, whether we are talking about trees, whether we are talking about any heavy machinery which is attached to the earth, now that is not movable property, that is all immovable property. The moment it is severed from the earth, it would transform into movable property. But what is the major change here is property of every description. Earlier it was restricted to corporeal property, now it says property of every description. It could be corporeal property, it could be incorporeal property as well. So, now we can handle instances of data theft in the BNS itself, although we had provisions in the IT Act, but you see BNS is the main substantive law dealing with crimes in our country. Earlier it was IPC, now it is BNS, which is the primary, which is the rather parent law related to substantive crimes. So, this has to be a comprehensive law, and when we already have a law, why should we be looking for other special laws or local laws? In case that can be incorporated in the main law, we can always take the help of those laws further. Then the definition of public servant, it has also undergone a change in the sense that under section 2 clause 28, while defining public servant, earlier juryman was also deemed to be a public servant, because that was the time when we would have a jury. There would be a foreman, there would be jurymen, and they would take decisions. In addition to the judge, there would also be a jury. But then it was seen that jury people could sometimes be swayed by other considerations also. And in our country, where we talk about the adversarial system, the judge has to sit as a neutral umpire, because we have to protect the interests of both the victim as well as the accused person. So, whatever is brought in front of the courts, that has to be appreciated, and on the basis of that. But sometimes jury people would bring their own notions as to what is right and what is wrong. Sometimes they could be influenced by considerations as to caste, community, religion. So, what that would bring a lot of subjectivity in the application of laws. So, when it was seen in the famous case of K.M. Nanavati, how the jury was swayed in favor of the accused person, and that was defeating the ends of justice. So, it was realized that we need to abolish jury system in our country, and we abolished jury system, but in the statute book, the term juryman was continuing till date. So, now when we had the opportunity, we have deleted the term juryman, because we no longer have jury system in our country. So, we no longer require jurymen to be defined as public servants. Then under section 2, clause 19, it defines man, and section 2, clause 35 defines woman. Earlier section 10 defined these together. Now we have separate definitions for them. Man is a male human being of any age, similarly woman is a female human being of any age. So, now we have defined these two separately. Then coming to the main changes in definitions in the procedural law, which is the Bharatiya Nagarik Suraksha Sanhita of 2023. Now, again all the definitions, they are in section 2(1), and in section 2(1) clause A. Audio, video, electronic means, how it has been defined, it says audio, video, electronic means shall include use of any communication device for the purposes of video conferencing, recording of the process of identification, search and seizure of evidence, transmission of electronic communication, and for such other purposes and by such other means as the state government may by rules provide. So, you see, like we have to, because introduce video conferencing as a means of examining witnesses, sometimes the accused persons also. So, now audio, video, electronic means it has been defined in a broad fashion, so as to include that whether it is any communication device which has been used for the purposes of video conferencing, whether we are also recording the process of identification, like see when we hold those test identification parades, now they all have to be videographed. Similarly, if the police is conducting searches somewhere, if the police is seizing some evidence from some place, the entire process has to be videographed. See, because earlier there would be allegations that maybe there was some evidence or some substance that was planted by the police themselves while conducting those search or seizure operations. So, in order to bring in transparency, so as to inspire confidence in the minds of people, what was required was that all this it needs to be videographed, and for that what we needed was to define what is audio, video, electronic means, and that has been done effectively in section 2(1) clause A. Next is the term bail. Now, bail is a term which we all have heard. See, there are two kinds of crimes that we talk about. Some are bailable offences, some are non-bailable offences. And what is a bailable offence? In which bail is a matter of right. And what is a non-bailable offence? In non-bailable offence, it doesn't mean that bail is not to be granted at all. What it means is that bail is a matter of discretion, depending upon the discretion of the courts, and that discretion has also to be exercised in a very judicious manner as per the established principles of law. So, in the non-bailable offences also bail is to be granted, but and on the discretion of the courts, and in non-bailable offences bail may be refused also. So, we all know what is a bailable offence and what is a non-bailable offence, but what does the term bail mean? Earlier it was not defined in the CRPC. Now we have defined this term. Section 2(1) clause B, it defines bail to mean release of a person accused of or suspected of commission of an offence from the custody of law upon certain conditions imposed by an officer or court on execution by such person of a bond or bail bond. So, the person would either be required to execute a bond, which would be some sort of a monetary consideration, which would be forfeited in case he jumps that bail, in case he does not appear before the court or before the officer when he is required to do so, or sometimes it could be on the basis of a surety. So, what is bail? It means release of a person who is accused of or suspected of commission of an offence, and he is to be released from custody of law, and that is a conditional release from legal custody. So, that is what is the term bail. The next is bail bond. So, when you furnish an undertaking for release along with the surety, surety could be a person also who is standing surety, that is okay, I take guarantee that this person will appear before the court or before the officer whenever he is asked to do so. So, bail bond means an undertaking for release with surety, and bond means a personal bond or an undertaking for release without surety. See, why we needed this kind of a definition clearly? Because there was an old judgment, Moti Ram's case, in which what happened? The court demanded a poor person to furnish surety of 10,000 rupees. Now, this person, he was a migrant laborer who was working in another state, he had no friends there, he had some property in the other jurisdiction, but the court said that you have to necessarily produce some property as surety which is within our own jurisdiction, and rightly so, because later on if we have to attach the properties or all to recover the money, there would be jurisdictional issues. But the lordships in that case, they remarked beautifully that see, rich people, they do not befriend indigents, due to which what happens, a person who is a migrant laborer in another state having no property there, where would he get such a huge amount of surety to furnish as his bail amount, 10,000 rupees, and that is I am talking about 40-45 years old case. 10,000 was a big amount at that time. Even today it is a big amount for a person coming from that kind of a background. So, now it could be either a personal bond, sometimes a person can be released on a personal bond. So, why this was done? In order to ensure that if somebody does not have anyone else standing surety for him, if he does not have money to give for securing his bail, does that mean that the person will forever languish behind the bars? So, in order to ensure that, we needed this kind of provisions, and now we have introduced the definition of also of the term bond, which means a personal bond or an undertaking for release even without surety. Next is the definition of the term electronic communication, which means the communication of any written, verbal, pictorial information or video content that is transmitted or transferred, whether from one person to another or from one device to another, or from a person to a device, or from a device to a person by means of an electronic device including a telephone. So, you see, anything which we have recorded by means of our telephone, that is also deemed as an electronic communication, and that has been acknowledged and given space under the criminal laws. Okay, so we will now read the complete definition. It says electronic communication means the communication of any written, verbal, pictorial information or video content that is transmitted or transferred, whether from one person to another or from one device to another, or from a person to a device, or from a device to a person by means of an electronic device including a telephone, mobile phone or other wireless telecommunication device, or a computer or audio video player or camera or any other electronic device or electronic form as may be specified by notification by the central government. So, a very, very broad definition. Now, coming to the conceptual changes via definitions in the evidence law, which is the Bharatiya Sakshya Adhiniyam 2023. See, the objective of BSA is to consolidate and to provide for general rules and principles of evidence for fair trial. Any trial has to qualify the test of fairness. See, the existing law, it does not address the technological advancements, and therefore we needed a law to fulfill the contemporary needs and aspirations of our people when the evidence law was enacted in 1872. Okay, when it was enacted at that time, you see, we did not have so much of technological advancement. So, how does such an old law fulfill the contemporary needs of our people? Although we amended our law in 2000, again we amended it in 2008, and that was done to incorporate changes in the wake of the Information Technology Act. But now we needed to totally overhaul the law. And why was it required? Because there was so much of a confusion, definitions being given in a haphazard manner. Wherever we needed new insertions, we would just add the section A, section B, D, C. So that is why it was introducing a lot of confusion. Now we have a better structuring of our laws by overhauling the same. See, in contemporary times, most of the evidence is found in the digital realm. So, if we were to continue by the old laws, if we were to still close our eyes to the fact that in majority of the cases nowadays, there is a 90% chance that one or more than one kinds of evidence would be of digital type. And if we were to close our eyes to this fact and not acknowledge digital evidences as a solid piece of evidence, as a sound piece of evidence, then what would happen? We would be ignoring the most vital piece of evidence in criminal trials. So, we cannot negate the evidence which is found in digital realm. So, now what does the Bharatiya Sakshya Adhiniyam do? It explains what is electronic evidence. It further explains what are the different kinds of electronic evidences, what are electronic documents, what are electronic recordings. So, all this and more it has been given in the Bharatiya Sakshya Adhiniyam. Even the definitions, when we talk about section 2, clause 1, subclause D, document, the definition, it has been amended now and it has been updated. Now, how does the Bharatiya Sakshya Adhiniyam define the term document? It says, document means any matter expressed or described or otherwise recorded upon any substance by means of letters, figures or marks or any other means, or by more than one of those means intended to be used or which may be used for the purpose of recording that matter, and it also includes electronic and digital records. So, now electronic and digital records are also a part of the term document. For example, there are certain illustrations and it says a writing is an document, right? We all know written documents, they have been accepted as solid piece or as strong and sound piece of evidence since old times itself. Then another illustration, words that are printed, lithographed or photographed, they are also documents. A map or a plan, it is also a document. An inscription on a metal plate or stone, see, even inscriptions on metal plates or stones, they are documents. Now, caricature is also a document. So, all this was earlier also accepted in the Indian Evidence Act as pieces of evidence. Now, what we have done? An electronic record on mail. See, most of the time what are we doing? We are communicating via emails. So, can emails be overlooked as a significant piece of evidence? No, we cannot afford to do so. So, now what does the law say? An electronic record on emails, server logs, documents or computers, laptops, smartphones, messages, websites, locational evidence and voicemail messages stored on digital devices. Now these are all documents. See what happens, most of the transactions, they are taking place in the electronic mode. When the accused comes to know that maybe he is under surveillance, the police are trying to apprehend him. So what do these people do? They try to remove all sorts of electronic or digital footprints. They delete all the data. But then sometimes we are able to recover that data from the memory of the phone, sometimes from the memory of the computer. Sometimes there are these kind of softwares that can be installed wherein we will be able to recover all those communications that are so vital for any trial that is being conducted in contemporary times. So now electronic record on email, server logs, documents, computers, laptops, smartphones, whether these are messages, whether there is any kind of information on websites, locational evidence, when you share the location and all those things. Sometimes you are sending voicemail messages which are stored on digital devices. Now in contemporary times, all these would be treated as documents and these would be accepted as evidence. Then section 2, clause 1, subclause E defines evidence to mean and include all statements, including statements given electronically. So how has the definition of evidence been updated? Because now we are also including statements that have been given electronic. Earlier the definition was only confined to all statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry, and such statements would be called as oral evidence. But now, even if the witnesses, they are giving statements electronically. So any statement which is given electronically, which the court permits or which the court requires to be made before it by witnesses in relation to matters of fact under inquiry, such statements. So now all those would be called as oral evidence. So even statements given electronically are now accepted as sound piece of evidence. Next is digital records. So now all documents, whether they are including electronic or digital records, which are produced for the inspection of courts, and such documents, they would be called as documentary evidence. So it is not only written documents which would be considered as documentary evidence. Now we have broadened the definition, and electronic records, digital records. So whatever has been produced for the inspection of court, those documents, even if they are in an electronic form, even if they are in a digital form, they would all be called as documentary evidence. So you see, oral evidence, documentary evidence, we have expanded the ambit of these evidences to include all sorts of electronic, digital communications also now. Then section 2, clause 2, it says words and expressions used herein and not defined, but defined in the Information Technology Act 2000 or defined in the Bharatiya Nagarik Suraksha Sanhita 2023 and the Bharatiya Nyay Sanhita 2023 shall have the same meanings as assigned to them in said Act and Sanhita. So now this is a clarifying provision which has been introduced herein in the Bharatiya Sakshya Adhiniyam. So there is a possibility that there might be certain words and expressions which have already been defined in contemporary fashion in either the IT Act or either the procedural law, which is the Bharatiya Nagarik Suraksha Sanhita, or the substantive law, which is the Bharatiya Nyay Sanhita. So sometimes those definitions, if we don't find their equivalent terms in the BSA or the Bharatiya Sakshya Adhiniyam, then those terms that shall be interpreted in the same manner for the purposes of this law also, in the same meaning that has been assigned to them in the place in the law wherein they have been put. So the same definition, the same interpretation, the same meaning would be assigned to those terms under the Bharatiya Sakshya Adhiniyam as well. Then section 61, which has been added, which is the most substantial change in the BSA. It defines what is an electronic or digital record, and it says nothing in this adhiniyam shall apply to deny the admissibility of an electronic or digital record in the evidence on the ground that it is an electronic or digital record, and such record shall, subject to section 63. Section 63 of BSA talks about admissibility of the electronic records. So, what does this say? That such record shall have the same legal effect, the same validity and same enforceability as other documents. So, you see, when we read that definition in the light of this section 61, we see how the ambit of Bharatiya Sakshya Adhiniyam has been expanded, and now all sorts of evidence. See, the focus is justice, the focus is protection of our people. So, all kinds of evidence, whether they are available physically, whether they are available electronically, whether they are available digitally, all those evidences, they would be pertinent for the purposes of our laws. So, main points. So, you see, evidence includes any information which is given electronically, which would permit appearances of witnesses, accused, experts and victims through electronic means, and electronic or digital records would now be admissible as evidence, and they would have the same legal effect, validity and enforceability as any other document. This law has also expanded the scope of secondary evidence to include copies which are made from original by mechanical processes. It has put limits on facts which are admissible and its certification as such in the courts. So, BSA introduces more precise and uniform rules of practice of courts in dealing with facts and circumstances of case by means of evidence. So, viewers, this will be all for this session. Hope you enjoyed the session. Thank you.